First District Court of Appeals now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good afternoon and welcome to the First District Court of Appeal. We have one case on the docket today, Richard Barnett and Martha Barnett versus Hibiscus Homeowners Association, Joel Richard Brain and Blair Brain. Counsel, if you're ready, you may proceed.
Good afternoon, Your Honors. I'm Kathy Giddings of Ackerman, and I'm here today on behalf of Rick and Martha Barnett, and I would like to reserve 4 minutes for rebuttal.
So noted.
Your Honors, this case is really very straightforward. I know you've got a lot of information in front of you, but it truly is. The trial court erred as a matter of law by substituting its own judgment for that of the association. The trial court found that all of the reasons given by the association for denying the Barnetts the right to construct the shared drive were arbitrary or invalid. And if the plan does not violate a specific provision in the declarations or other restrictions, it must be approved. But then under section 720.3035 and the cases cited in our briefs, the trial court should have stopped there. Instead, it went beyond the reasons by the association and came up with its own reasons for denial. Now, if you look at page 30 of the answer brief, it agrees that the trial court cannot do this. It cannot impose its own personal reasons. But its brief takes the trial court's reasons and elaborates on them and comes up with even more pretextual reasons for why the denial was appropriate. It raises many issues in its answer brief that were never raised before.
Okay, if you could, let's try to get this to simplification a little bit, and that we would appreciate and I think benefit from that. Let's start with the arbitration decision. Who is that binding on and why?
The trial court made a factual finding that it was binding, and it was not binding on the association, even though the association's board members developed it. However, I think that we've gotten a bit distracted with the whole arbitrated solution, because the point of the arbitrated solution is that the association kept telling the Barnetts that it would only accept the arbitrated solution in an application. Now, Mr. Barnett is a smart, sophisticated, and seasoned architect. He believed his solution worked much better than the arbitrated solution. So he spent quite a bit of time trying to convince the association to adopt his solution. But after they told him, no, we're not going to approve anything but the arbitrated solution, he said, okay. So he submits an application.
Was the arbitration solution binding on the appellants as well as the Bryans?
It was binding on the Bryans and the Barnetts. The arbitrated solution, everybody understood that the association would still have approval of certain aspects of the plans, but remember that at that point in time, none of the houses had been built, and you have an association cannot deny something simply because it doesn't like it.
So this wasn't an arbitration under Section 4 of the ARC article of the Declaration?
It was an arbitration that the parties agreed to in the shared agreement. And
so it was a private arbitration that didn't involve Article 5 of the Declaration?
We alleged that in our complaint, Your Honors, but after discovery, we realized that it was an arbitration that the parties had asked for the board to approve. But I mean, I don't want you to get distracted here by the arbitrated solution, other than to know that the board insisted for years. If you look at the record, there are many emails that talk about you have to submit the arbitrated solution to us, the association, or we're not going to approve your drive. So they were arguing over whether the association would approve that arbitrated solution, approve their drive with a different solution from the arbitrated solution, and they told them, no, it's got to be the arbitrated solution or we're not going to approve it. So that's why.
But that was sort of an informal type of guidance.
Well, no, they denied. sent them emails telling them, if you do not submit the arbitrated solution, we're not going to approve your application. So that's when Mr. Barnett finally said, okay, well then we'll submit an application with arbitrated solution. And remember,
So if you would have submitted a full and complete application with all those aspects that they wanted you to submit, and they would have nixed you on the driveway, then you would have gone to an arbitration that would have bound, or potentially gone to an arbitration that would have. I'm just trying to figure out what the effect of this arbitration was on the.
well, the effect of the arbitration was that it bound the Bryans and I know it's called the Brins. I've been told that you pronounce it Bryans, but there's also Fred Bryant who owns one of the parcels, so it does get confusing. But I've been told that it's binding. It's binding them to them. They are the parties to the shared agreement. But remember that the law states that you cannot disapprove something as an association if it's available under the declarations. And Mr. Varnum testified at trial that in 2011, the homeowners' declarations were expressly amended to allow this drive to be put in, and I believe one of Mr. Bryant's shared access. So the declarations envision the shared.
Was the ARC bound by the arbitration panel's plan?
The ARC was not bound by it from a standpoint of they weren't a party to the contract, but they are the ones that came up with this solution. So it's very disingenuous of them to say that, they said, we're going to accept the arbitrated solution. That's what this whole case is about. That they said, we're going to accept the arbitrated solution we still get to say some other things, where the bricks are going to be laid and where the curb's going to go in. But the arbitrated solution is what they told the Barnetts that they had to submit with their application, with their house plans.
And you keep referring it to as an arbitration solution. Is it in fact an arbitration decision under Chapter 44?
No, it's not under Chapter 44.
And so how would it be enforced? How would that arbitration solution be enforced if we're only talking about the Bryans?
Well, the Bryans are bound by it. They understand that they are bound by it, and a shared drive they are entitled to a shared drive over their. We are entitled to put a shared drive over their property. They are bound by that.
And I understand that, but my question is, how would your client enforce that right? What is the cause of action to enforce the right as to the Bryans?
This case, the only reason the Bryans are here is because they're an indispensable party, because their property's at issue. The issue before this court is whether the association acted arbitrarily and capriciously in violation of the statute and the case law in disapproving the Barnett's application with the once they did acknowledge that the arbitrated solution was binding. So keep in mind, if you look at section 720.3035 and the case law that we have cited, it expressly states that you cannot deny things for arbitrary reasons. And the trial court made a factual finding.
But the trial court specifically found at paragraph 3 of its order that the Barnett's complaint does not include a cause of action against the Bryans to enforce the arbitration panel's binding decision 5 years after the Barnett's rejected that decision. Now, shouldn't you have brought in a cause of action against the Bryans as well?
No, Your Honor. We brought them in as they're an indispensable party, but we keep thinking that this arbitrated solution is what we're here on. We're not here on that. We're here on the fact that the association said that if you submit the arbitrated solution, then we'll look at it, but we're going to deny anything else. So it's not that arbitrated solution is what controls this. What controls this case is that once the Bryans and the Barnetts had a falling out, and Mrs. Bryan was the secretary of the association, every single thing the association did after that favored the Bryans over the Barnetts, and they cannot do that. And they said, in fact, if you look at what they did, they said, submit your application with the arbitrated solution, and we'll take a look at it then. We submitted it.
For the sake of argument that we reversed the trial court.
I'm sorry?
Assume for the sake of argument that we reversed the trial court in this proceeding. What effect would that have on the Bryans? Could they then come back like the Barnetts did? and reject arbitration?
No, they,
Why not?
Mrs. Bryan has admitted, and they even admitted in their brief, even though their brief is very short, they admit that the arbitrated solution, that they are bound by the shared access agreement and the arbitrated solution. So that's not an issue here. The issue is whether the association acted arbitrarily in denying it. And remember, what happened was, they put in the Barnett submitted their application in early 2019, and in 2019, the board comes back, the association comes back and goes, oh no, you've submitted it with arbitrated solution, but now we want a plat amendment. Well, the county said, you don't need a plat amendment. So then the trial judge, so then they come back and they go, we filed this lawsuit because they said you need a plat
Yes,
amendment.
counsel, but couldn't it be said that the appellants violated the shared access drive agreement by rejecting the location of the drive chosen by the arbitration panel?
No, Your Honors, I would
Why not?
disagree with that, because that agreement was binding as to those parties regardless, and whether Mr. Barnett originally didn't realize it was binding, but once he understood it was binding, he went forward with using the arbitrated solution. But what we're talking about here
Then,
is,
next question.
Okay.
Why is the current ARC bound by the location selected by the arbitration panel approximately 5 years before appellants finally accepted the location?
because the association has to approve it if it can be reasonably applied if it can be reasonably inferred in the declarations. Listen, for years, what happened was, once they realized a plat amendment wasn't required, they said, okay, so it's unsafe. They'd never raised that before. Then they said, nobody else has two access drives. They'd never said that before. We won't approve it unless you abandon access off 30E. No, we won't approve it ever, because we can deny it for
and that
any
part,
reason.
I think it's very clear that they're moving the goalpost on you. That all of this even 2016, when you have that email that's basically saying it needs to be consistent with the arbitrated solution, that everybody's on board. There was 14-0 vote, I guess, back of all the property owners back in the day, us acknowledging the shared driveway. So shared driveway was everybody's expectation until at least 2016.
Right.
After that, things went haywire, I don't know, and the goalposts started moving.
That was about the time.
But to the extent that they aren't bound by the arbitrated solution, I guess the question is, to what extent can they move the goalpost at that point? What bound them pre-2016 to not saying, no more shared driveway, we're going to do what we want to do?
Because the statute...
For safety reasons even, for any
Right,
reason.
well, yes, but the trial court rejected all of those reasons and then came up with its own reasons. So those reasons, the statute says that a board cannot act arbitrarily. If it's reasonably implied in the declarations, they have to approve it. Here, it's reasonably applied in the declarations, and everybody, it was a done deal for years. Everybody acted as if this thing was a done deal. And there are 6 criteria in the declarations. If you look at it, it talks about, in Article 5, I believe it is, it lists 6, or Article 3, it lists 6 criteria. And it's things like, we can tell you where to put the bushes beside the road. We can tell you what kind of bricks. And remember that the Bryans, when they built their house, the association approved the drive, and it was actually started. But then the Bryans didn't finish construction of it.
So there's no question, there's no dispute in the record that the association approved the Bryans' shared driveway plan.
Yes, there is no question about that, Your Honors. No question about that. And it acknowledged that Mr. Barnum, who was the chair of who testified at trial, said that the declarations were amended to allow this drive. He said there was no question in his mind that they were amended. So the statute says, if it can be inferred in the declarations, and here we have testimony that it's not only inferred, but that that is why it was put in there, then it has to be approved. And if you look at...
Did the area need to be replatted for a shared driveway?
I'm sorry?
Did the area need to be replatted?
No.
For a shared driveway?
No, the county said, as long as there is an individual agreement between those property owners over where that private road's going to go, which we have, as long as there's that individual, that no plat amendment is required. And in fact, when the association said, well, you've got to abandon that access before you can put in the shared road, the county said no. If you look at the county's letter to them, it says you can put in the shared drive, but you can't abandon this other access because that would require a plat amendment. And I think it's really important for Your Honors, I'm way into my rebuttal time, but I think it's really important to understand that the need for the drive was because you didn't have access to 3 that was viable. And I'll save the rest of my time for rebuttal.
One more question, Counsel. Are there other shared driveways in the Hibiscus development?
Yes, there are, Your Honors. Mr. Bryan himself has one, not the Bryans, but I believe it's Mr. Bryant that has a shared access in there, and the declarations expressly state that.
Does the declaration, is it the same, do the declarations still reflect the 2011 amendment about shared driveway for 1 through 5?
Yes, they still have them all in there, 1 through 5, and a bunch of other lots. And I'll save the rest of my time for rebuttal, Your Honors.
Thank you, counsel. I will extend your time by 2 minutes, and I will similarly extend the time for the appellees as well. Thank you.
Thank you. May it please the court, my name is Jennifer Weingardner, and I am here on behalf of Hibiscus Homeowners Association. I am going to, the Brains attorney is here as well. He has ceded his time this afternoon to the association. So I will be using the allotted time. Your Honors, this case is about whether the Architectural Control Committee, the ARC for Hibiscus Homeowners Association, acted reasonably when it rejected the appellant's construction project. That's all this is about. The trial court correctly held, or more precisely, the ARC's decision to reject the construction project was not unreasonable because the project was not consistent with the plat, not established in an arbitrated or agreed location, and had been clearly rejected by the appellants 5 years before. That's what the trial court held. Now it's this.
But the area did not need to be replatted for purposes of the shared driveway, did it?
Your Honor, let me explain.
Based on the testimony of the representative from the county.
The county did not require a replat. The plat requirements in this case were akin to a private agreement between all of the lot owners. Just like covenants and restrictions are, when lot owners buy a lot, a piece of property within a subdivision, they buy it in accordance with the covenants and restrictions and the plat. The McCorkle case cited in our brief lays this out. This has been decades-long case law. So every single lot owner in there, when they bought their lot, it was a lot that they bought with the understanding that they had to comply with the covenants and restrictions and that they had to comply with the plat. The fact that there were other regulatory issues related to the plat, the county may have had obligations, is irrelevant to the private agreements of every lot owner. And if you look at the testimony throughout for years as these parties were negotiating this shared driveway, so the fact that there was a shared driveway was not the problem. But from the very beginning, in 2010, Mr. Hofer, who sold these lots to the Barnetts, told them, you're going to have to get a plat amendment. The plat amendment wasn't a county compliance requirement. It was so that every single homeowner in that subdivision would agree that they would change the access points, the ingress and egress in and out of that subdivision. And Mr.
So what effect did the unanimous vote in 2011 have? That everybody was on notice, no objection, everybody said the shared driveway to lots 1 through 5 are good by us. Does that have any effect?
No, there was no vote among the homeowners association to approve a plat amendment. So
well, I understand that. I didn't ask about a plat amendment. I asked about shared driveway.
Oh, no.
This idea about a shared driveway.
Yes, I understand, Your Honor.
My understanding of your case is that there is not a plan that they could submit to you with a shared driveway that you would accept at this point. Is that wrong?
I don't know that that's accurate. There may have been testimony in there. The shared driveway agreement in and of itself, it was accepted by the parties.
So all we're talking about here today is you didn't like this plan, but there is another plan for a shared driveway in the same general place. I mean, we're only talking differences between me and the chief, or maybe me and Judge Lewis about a bend and straight or bend or how bendy it is, but it's a very tight space. Would the homeowners association approve a plan of a shared driveway that runs to lots.
Yes,
lot
and
three.
and the association indicated that, but the way that the plan that was submitted to the association allowed the exterior, so we're talking about a gated community with 3 exterior lots. Those 3 exterior lots had ingress and egress right out onto the county highway, and it had one gate
Yeah,
in
I'm
and
not
out of the
talking about
association.
that, I'm talking about the shared driveway.
No, there was no issue with the shared driveway, the fact of a shared driveway. What the issue was, is as soon as they changed the access points into and out of the community, as soon as they superimposed or took out a pedestrian walkway, those elements changed the plat itself and would have changed the ownership rights of every homeowner in there. And initially, when Mr. Hofer was explaining this to the Barnetts, he said, you know, I own several lots, I have a lot of votes on this, I have proxies, we can probably get this through. But by 9 years later, things had changed and they didn't have the votes to get that through. So,
Is there a shared driveway? You go through the front gate, you take a right. Is there a shared driveway that could be put in there that would be acceptable to the?
I think the homeowners association thinks there is. I think the issue
So we're
is.
just talking about whether it's a foot here or.
Right, right. So everybody agreed at some point in concept, right? So there was an the agreement between
And
the
they
parties.
still agree.
I think they do still
The
agree.
concept
In
is
the
still
concept,
alive,
it was
it's- So we're just arguing over a foot this way versus.
the nuts and bolts of it. And the brains agreed from the
Will
beginning.
the association require the Barnetts to close off access to Lot 2 from 30E to approve the shared driveway?
I think what the association has said and what the trial court has held is that they can approve that if they get a plat amendment, meaning the internal agreement among the homeowners that they will change the character of that neighborhood. And that is what the trial court held. You have to have agreement of the homeowners. And that is what from day one, from 2010, the Barnetts were told that the plat would have to be amended, that there would have to be agreement among the parties. So you have a couple layers of agreement here. You have the parties agreeing, you have the Brains, and you have the Barnetts agreeing. But everybody always understood that had to go to the ARC for approval and to the Board of Directors for approval. And when it got to the Board of Directors, they're like, you can't just change the character of this neighborhood without affecting the property rights of everybody in here.
But that seems to be an argument as to the whole project. And what you just told me is that there is a shared drive, go through the front gate, you take a right, there is a shared driveway that could be built there that would be acceptable. And now you're telling me I think that really that wouldn't be acceptable because of this other issue about access points down the street. So which is it?
Well, correct, Your Honor, we'll go back to the trial court's order, which said it was not unreasonable for the association to require the plat amendment because they were changing the character of the neighborhood. But in concept, the shared driveway was not a problem. The parties never agreed to the nuts and bolts of where that driveway would actually be. And the trial court looked at that too and said, you don't even have an agreement among the two parties that are most immediately affected.
Well, they do through the arbitration solution. The two parties are good. They've got the arbitration solution, which I understand it was now before the homeowners association, and it's getting nixed. And because I guess there's some other way that the homeowners association wants to draw it, even though they're not going to nix the whole idea. It's just a matter of deciding which feet of ground within a very small area gets pavement.
Correct, and there's also the going back to the fact that you have to get all of the members of the association to agree to change the character of the neighborhood. So when you buy property and you've got 15 lots in a gated community and you're adding another 3 lots within the gates, and you're changing the ingress and egress with the gates, everybody needs to sign on to that.
So the neighborhood has already told them that they can have this shared driveway running from lot 5 to lot 3,
Correct?
but they can still withhold it in the end, is what I'm hearing you
Well,
say.
no, Your Honor, let me clarify. It's not the shared driveway that's the problem. It's the fact that there's, that the ingress and egress right out onto the county highway is the problem. What would happen is if the association said, okay, and by the way, they're exercising their best business judgment. We're going to allow you, lots 1, 2, and 3, to have 2 ingresses and egresses into this community. That's supposed to be gated, that everybody but as a gated community. Now you've got the neighbors next door and the neighbors down the road. Everybody else along County Road 30, you'd have a selective enforcement problem. If you allowed 3 units to have 2 different ingresses and egresses, you'd be obligated to allow everybody, and the whole character of the neighborhood would change.
But the Barnett's ingress and egress from that highway was always there. So why isn't this something that entered the conversation back in 2011 and 12?
It had never gone to the board before then. And so it was always assumed from 2012, from 2013, 2015, they were always told, this is still going to have to go to the board. We're still going to have to get it. They were told they were still going to have to get approval from the board and from the homeowners in the community. It just hadn't made it that far yet. And so when it made it that far, they told them again. Your Honors, in 2013, they were told that all construction would have to be approved by the board. In 2014, they were told that ingress and egress to lots 1, 2, and 3 had not been ARC approved, and there was still no agreement. In 2015, they were told that since the Barnetts had rejected all of the arbitrators' ideas, which the ARC rejected because the plans would violate the plat. They were told this in 2015. They were told it again in 2016. In May of 2016, the ARC indicated they would not approve construction that deviates from the plat, that it could not approve a new driveway in conflict with the plat. Again, in 2018, the homeowners
Counsel, I think you may have touched upon this, but if ARC previously approved a shared drive for lots 1 through 3, under what authority did the current ARC reject appellant's latest proposal?
I'm sorry, can you repeat that?
If the ARC previously approved a shared drive for lots 1 through 3, under what authority did the current ARC reject appellant's latest proposal?
They rejected it on the fact that it didn't comply with the plat.
I don't see that in the 2016 ARC email. It says, it doesn't say anything about plat. It says, we're not going to prejudge your driveway submission. We, the ARC, are concerned about the current driveway plan deviated from the arbitrated driveway location. So it seems like what they're concerned about, not the plat, but about the arbitrated driveway.
Right, that was part of the conversation.
That's what the ARC's expectation was.
Right, that's part of the conversation, and what the ARC was telling them in other conversations was you have to abide by the plat. And it also told them repeatedly, once the ARC approves, it has to go on to the board to approve it. So nobody, not one person, Mr. Hofer was saying, I'm going to try to get you this approval, but you've got to go through some hurdles. First of all, get the immediate affected property owners, 1 through 4, to agree. Second, get the ARC to agree. And third, get the whole board to agree with the whole community. And at the beginning of this whole process, Mr. Hofer said, in sort of a trying to get this deal through, I know I have votes. I have a lot of lots. I have proxies on votes.
It seems like everybody was on the same page in 2016, except for the Barnetts. Everybody was on the same page as to the arbitrated solution. That's how I read the record, that the expectation was that this arbitrated solution, there was an agreement with the homeowners, so check to the first part. The second part, that the board and the ARC was really vested in this arbitrated solution, and the conversations were regular, back and forth. And so the expectation of everybody was the same at that point, except the Barnetts were the outliers. We reached 2019 and the Barnetts come on board, but then the board of the ARC or somebody has now fled, and now they're out saying, no, all this stuff was never, this is foreign to us, we would never have agreed to this. And so it just seems to me, like I said earlier, that the goalposts for purposes of the ARC and the board are moving, and why am I getting that wrong?
Well, the board had never approved or considered.
Well, I get that, but they
no,
were very
they had
vested,
never
right?
considered. They had never considered the submission until it had gone through. The ARC is the only one that rejected it. Those are two different bodies.
Understood.
So the board hadn't, the ARC hadn't rejected it until it did, and the board still hasn't reviewed it or approved it. After the ARC rejected it, the lawsuit was filed.
And I guess my point, the board was very vested in all of this, even though they hadn't received the complete application. I mean, that's home orientation, that's septic, that's all this stuff. But this huge issue was out there that seemingly got resolved in 2014, except for the Barnetts. It took them years to get on board, but
Yes,
but they did. But at that point, the ARC and the board were.
From the 9 years that this issue was going back and forth among between the homeowners and with the arbitrators and the ARC, under no uncertain terms was it ever represented by the association that the plat would not have to be amended. They said repeatedly that the plat would have to be amended. It was only when the Barnetts went to the county that and the county said, for our purposes, it doesn't have to be amended. But the county, think of it like in a homeowners association when you have lot line setbacks. You have a city setback that says 10 feet, but you have a private covenant restriction, or you have a plat that says setback's 20 feet. The homeowner still has to comply with all of that. So all these people that bought the lots within the subdivision bought understanding there was going to be one gate in and one gate out, that there were a certain number of lots within the gated portion of the community, that there was a pedestrian walkway. By the time and by the way, the fact that the plat, the consistency with this agreement, had to be consistent with the plat was something that was repeatedly mentioned. It was when it came to a head and the ARC said, no, I mean, we're serious. You have to abide by the plat. You have to get all of the owners on board to amend the plat. Shouldn't have been a problem in 2010 or early on, but it became a problem later. Things change. Lot owners change. Everything, you can't guarantee a 26 or 15 homeowners within the gated portion of the community were not going to change their minds after 9 years.
But the ARC approved the Bryans' plan to develop their lot, which included the shared access driveway, right?
Correct, but the shared driveway is not the problem. That didn't change the nature of the community for the rest of the lot owners within the gates. That didn't open up the other 3 gates to the community. That didn't change that. That didn't invite more traffic. And there's case law in our brief that talks about that. When you change the nature of a community by opening up more gates, you're inviting more traffic, you're inviting more access. The other residents within those gated walls didn't bargain for that.
Are the other residents bound in any way by their having amended their declaration to say that a shared driveway running from lot 5 down to lot 1 is part of our vision and part of what we're...
Yeah,
are they bound by that? Or
yes.
Could they reject any plan that comes at this point? Because as you just said, well, now it's all changed because you have different residents perhaps and different people involved. So does that amendment to the declaration in 2011 mean anything? Does it bind them at all?
It does bind them because it was passed. And they went through proper channels, proper corporate procedure, and they passed the bylaws, just like any other amendment to covenants and restrictions.
So this is all about just picking the right route, that they can't, every route can't be rejected. There is a route.
Yes.
And again, we're talking about, functionally, there's probably only two or three options, right? I mean, it's such a small space.
Yes, and I think the board indicated that you will, we're encouraging this. We're inviting you. They've invited them to reapply. They invited them to submit new plans. We encourage you to submit new plans, but this access way is going to be a problem. Or you can amend the plat.
But the
with a
arbitrated
vote.
plan did entail the location of the driveway, right? The arbitrated plan
Yes.
did include the location of the drive.
Correct. But the shared driveway situation doesn't change the ownership interest of every other owner in that subdivision. The access in and out and the nature of the gated community does change the ownership interest of everybody else in that subdivision. That's the ultimate problem. And so this court has to look at whether, when the trial court held that, the trial court held as much and said it was not unreasonable to reject this because they needed to get a homeowner approval and change the plat. They didn't have homeowner approval even in the immediate members. And so what the court has to look at is whether there was sufficient evidence in the record to support that. That's all, the trial court should be affirmed. That was a judgment of fact that the trial court made. Is there sufficient evidence in the record to support that finding? And there's a plethora of evidence. We've gone through every year that the Barnetts were told, you have to get this, you have to be consistent with the plat. You're going to have to get a plat approval. You're going to have to amend that plat. They were told repeatedly for years and years and years. And when it came to pass and they were told you have to amend the plat, now they're saying it was unfair. They were told that from day one in 2010 that there was going to have to be a plat amendment. And the county's Rejection of that need has nothing to do with the private rights that that plat created inside that association. So with
Counsel, you're about a minute and a half over your time. I'll give you
I
30
apologize.
seconds to wrap up.
I have nothing further, Your Honor, if you have no
I do
further
have a
questions.
question.
Yes.
Were the Bryans required to amend their plat or get a new plat to construct their building with the shared driveway plan?
No,
Why not?
because they didn't change the nature of the community. They didn't open up the gates. They were allowing an easement on their land, so they were sharing a driveway
What do you
on
mean
their
by-
property.
What do you mean by open up the gates, excuse me?
Well, the access, ingress, and egress on lots 1, 2, and 3 was in and out of County Road 30.
Right.
And so traffic or cars could come in through County Road 30 and enter into the subdivision through the driveway. Whereas in the current situation, that's all gated, and the only ingress and egress for people to get in and out to the subdivision is through one gate. The association offered the Barnetts to gate their access, and that didn't happen.
Is there any evidence in the record that not closing off access to Lot 2 and 1 and 3 from 30E would cause a safety concern or safety issues? Is there any evidence in the record of that?
There's no evidence in the record, but there's case law cited in our brief that talks about the nature of opening up gates to an association by just would change or could potentially change the character of the neighborhood. And I think the owners have to vote on that. If they're going to change the gate and how many gates are on their community or how many gates are not, the homeowners within the platted subdivision have to vote on that.
Thank you, counsel.
Thank you.
I'll ask the clerk to add 3 minutes and 20 seconds to the appellant's time.
Your Honors, respectfully, I'm not sure we're looking at the same record here. If you look at paragraph 50 of the trial court's order, it states, in 2016, Graves advised Barnett that the ARC would only approve a set of plans consistent with the arbitration panel's decision. In 2019, Graves advised Barnett that the ARC would never, and had never, and would never approve the access drive over Lot 4. They have repeatedly, even though, Judge Lewis, the Barnetts have already fixed it where you cannot come across the access coming into 2. All of this stuff about it changing the dynamics of the neighborhood, that's stuff they created during this appeal. That's not stuff that the trial court found. They have said we are never going to allow you to have the shared drive. And at the time the Bryans had started their construction, you have to remember it's lots 5, 4, 3, 2, and 1. And the only way to have adequate access to Lot 3 is from Hibiscus within the subdivision. That's what all of this is about, because when you have the access off of 30E, when you come in, it only comes to Lot 2. And when you go to turn to Lot 3, you cannot make that turn without going way on the easement on Lot 2. Well, the association, after they got in a dispute, said, well, you guys own all 3 lots now, so that's your problem. Go ahead and figure that out. But everybody knew that this was a done deal. The declarations were amended, and the trial court found that they could not deny any shared drive. That was the reason the court said that that would violate the statute. They are not telling them come back and we'll approve a shared drive. They're telling them that we're never going to approve another shared drive.
I asked that question directly, I think, multiple
And
times.
I
I heard that the problem is with this particular application, that there is a plan, there is a drawing that could be done, a shared driveway that could be built there.
Your Honor, all you have to do is look at the letter of October 23rd, 2019. What I've got is at the record at 118, and it's on page 119, but it's in the record dozens of times. And it says, the Hibiscus Architectural Review Committee will not approve an additional access route to your 3 lots. Please provide future site plans for home submission using the platted access route. I mean, that's what the letter says. Counsel's representing something different, but that's not what the record reflects. And this whole thing that has been recently made up about it changing the characteristic of the neighborhood, nobody's going to be able to use that access except for the owners of the lots. And if they need to bring in a construction vehicle or something, they'll give them the gate code. And
Right.
so I
And if
think
hypothetically the Barnetts were to sell Lot 3, there would have to be something constructed.
Exactly,
right?
Your Honor. That's what, the association's treating this, because the Barnetts own all 3 lots, they're treating it like, well, it's your problem, you own those 3 lots. But the Barnetts have already shown that, who wants to live in a subdivision where everybody hates you? And so the Barnetts would have to have adequate access to their lots to be able to sell them. But there's not going to be a million people coming in and out of that gate. And so all of that, and that was never a reason that was given.
But let's just take that argument at face value that that there could potentially be a change to the nature of the association in the neighborhood. Again, if you had a new purchaser on Lot 3, wouldn't that necessarily change just by the transfer of that property?
They're going to be bound by the covenants, Your Honor, and they're going to have to, if there's a gate there, they're going to have to abide by who can come in and out of that gate. But I think that if you look at White Egret Condo from the Florida Supreme Court, Ladner versus Plaza del Prato from the 3rd, Young versus Torta Island from the 5th, and this court's cases in Killearn Acres and Keeves, a court cannot arbitrarily and selectively come in and say, all right, we approved this for one person, but we're not going to approve it for another. They've already approved shared drives within there. Everybody thought it was a done deal with the arbitration agreement, and the statute 720.3035 says if it can be reasonably inferred that it's permissible in the declarations, that it has to be approved as a matter of law.
Counsel, I understand your argument the trial court should have ended at paragraph 56 of this order. But from your perspective, unfortunately, the trial court went on with paragraph 57 and 58. Specifically, paragraph 57, the court states, the courts cannot find that ARC's decision to reject a shared access drive that is not shown on the plat was unreasonable or arbitrary. Address that.
Your Honors, the plat, first of all, they said that the plat amendment was raised early on. It was not raised early on. It was first mentioned to the Barnetts in 2016, and it was not officially stated that they had to have a plat amendment until 2019. And there is no requirement for a plat amendment because there's a shared access agreement among the property owners there. And it's implied by the declarations. The ARC can have approval as to where the curb goes in, that kind of thing. It can tell them where the bushes are. It can tell them what color the gate has to be. It can tell them what color the bricks have to be on the road. It cannot deny them that access as a matter of law under the statute, under the cases. So the trial court was wrong in holding that. It's really, I could see this court issuing a 1-paragraph decision just saying trial court can't interject its reasons of its own. They cannot deny, the trial court held that they could not deny a shared access drive on any basis, and we would ask that this court reverse and remand for entry of judgment in the Barnett's favor with directions that the association cannot deny them the shared drive.
Thank you, counsel.
Thank you, Your Honors.
Thank you both. This court is adjourned.
All right.
Nice to see you again.
and I had to bring